Okay.
As soon as Attorney Sauter connects, then we'll get going.
Very well. Good morning, everybody.
And Attorney Hoffman, it looks like your mic might be low. You just spoke and we hardly heard you.
Oh, the volume is low?
Yeah.
Oh, okay.
Yeah.
Um,
Good morning, Attorney Sauter. It's showing as connecting to audio.
Yeah, I don't know what's wrong with his audio link. Let me call him real quickly. He's going to log out and log back in. There's some reason the audio didn't connect for him.
All right. Well, why don't you stop the YouTube
Okay.
and we'll restart it.
All right.
Okay. Is YouTube stopped at this point, Mark?
Yes, I put it on pause.
All right. Alternatively, are the other attorneys ready? I mean, we can try switching the cases.
Yeah.
And that'll give Attorney Sauter a little bit more time to figure it out, because if he's using the Wi-Fi, I don't know if his Wi-Fi is anything like our Wi-Fi.
Well, I just admitted him. Let's see if he connects this time.
Testing.
Okay.
Can you hear me?
Yes.
We can hear you, but okay, there we can hear
There we
you.
go. Now we're cooking.
Okay, you look familiar. Do we know you?
Long time no see. How's everybody?
Okay, Mark, go ahead and restart the YouTube, please.
I did.
Okay, thank you. All right. Well, good morning, everyone.
Good morning.
Welcome to the First District Court of Appeals. This morning, we have two cases scheduled for argument. The first case is State versus Lessingame, and the second is Cummins and Brown versus Phyllis Brown. Cummins and Brown LLC and Phyllis Brown versus James Cummins. For the second case, Judge Winkler will be sitting in for Judge Myers. Now let's go ahead and move forward with the first case. So State v. Lessingame, case number C190555. If parties can please state their name.
Zayas, I think it's Anderson.
Oh, pardon me. State v. Anderson, that's correct. So State v. Anderson will be the first case, and that's case number C190588. Thank you.
All right. Thank you. And please, the court, counsel.
Your microphone is quite low.
Okay, I apologize. I tried to turn it up. I'll try to speak up.
You're good now.
All right, thank you. I represent Mr. Anderson, and this case is it's a conviction for trafficking in cocaine.
And
That was the
Attorney
result of-
Hoffman, would you like to reserve any time?
Oh, thank you. 5 minutes, please.
5 minutes, okay, no worries.
And part of the plea bargain involved his pre-sentence release from confinement. And it factored into the plea bargain. This was back in 2015. And as a condition of his release, the trial court made an agreement with him that if he failed to return for sentencing or if anything bad happened, he wouldn't be looking at an agreed 3-year sentence. He'd be looking at an 8-year sentence. And this was not an agreed sentence. It wasn't suggested by both parties, but it was agreed to by the defendant and the trial court. Well, my client didn't appear for sentencing, and many bad things happened. And in 2019, at the sentencing hearing, the trial.
And there's nothing inherently wrong with the trial court saying, "Hey, I'm going to give you X amount of time, but if you don't show up, I'm going to give you an increased amount of time." You're not saying there's anything wrong with that, is there?
No, Your Honor, I don't.
And in fact, under State versus Cherry and State versus Chandler out of this district, it's even a factor, failure to show at sentencing is a factor that the court is permitted to use to enhance a sentence, is it not?
That is also correct. There were I found maybe 4 cases where this kind of scenario came up, but the sentence was challenged on appeal, but this court found that the factors were considered. But in this case, it's a little different because I found a couple of statements which could be considered affirmative statements that the trial court was relying only upon the plea deal. In other words, it limited its consideration just to that bargain, and that was it.
Under
Isn't there
the
also-
recent,
Go ahead, Judge Myers.
under the recent Supreme Court case, are we even permitted to review the 11 and 12 factors to determine whether the record would support it?
You mean, is the Court of Appeals allowed to weigh the factors?
Correct.
Well, I don't know anything about that, but I'm not sure that really applies to my argument, Your Honor. It's more a case that the trial court didn't consider it and it was supposed to.
That's what I mean. Can we even review that anymore?
Well, yeah, I think so. I think it's a mandatory duty to the purposes and principles of sentencing has to be considered, and the seriousness and recidivism factors have to be considered. And I know there's a presumption, but I mean, a presumption is just that. If you've got a fact that contradicts the presumption, that presumption doesn't apply anymore. And another thing, you know how trial courts, they take actions without explaining it very often because that's what trial courts do.
Well, Attorney Hoffman, during the sentencing hearing, the court said something to the effect of that your client was on probation for a gun charge, that he had committed this offense and that this was a serious drug trafficking offense. So what do we do with that language?
Well, I guess you certainly are free to use that and say that his statement. Those statements are reflective of the fact that he might have considered it as a seriousness factor. It might have been considered in the context of seriousness of the offense, or maybe recidivism, or maybe punishment of the offender. But I think it's a stretch to say, well, it's the protection of the public. I think you're reading too much into it. And then you also have those affirmative statements. I mean, I don't mean to beat a dead horse, but he made the statements. Defense counsel said, well, there are these factors you have to consider. And then the trial court just didn't do it. And I think that when it comes to presumptions, if you have facts that contradict a presumption, you don't have to win it can bring it to 50-50 likelihood. It doesn't take much to overcome a presumption because a presumption is just a presumption.
Well, but I think that the difference here is we have 2 different hearings. And in the first hearing, there's certainly discussion of the issues that are the 11 and 12 factors in some form or fashion. And then we get to the second hearing and he said, well, I considered this all before, and I told you this is what I was going to give you. So like, why isn't what was discussed on the record of the first hearing sufficient?
No, I don't remember that, Judge. I remember a plea bargain for 3 years, and I remember a threat for 8 years. I don't remember any discussion of factors being considered. It was a plea bargain hearing. It wasn't a sentencing hearing. It wasn't even time to do all that. Now, at the time the promise was made, I'm sure there's nothing improper about promising a certain sentence as a part of a plea deal, but there was no agreement that the judge could waive all his mandatory considerations when he turned around to impose it. That's different. There wasn't an agreement about that. And so it brings me, it almost makes me wonder if the trial court was trying to follow State versus Little. Because this fits Little like a glove. And I think the reasoning in Little is improper. I think you can't impose an illegal sentence just because somebody agreed to it at a plea bargain. I mean, because you can't draw the line anywhere. Where do you draw the line? How much of an illegality are you going to put up with? It just doesn't work. And I think that's what's going on here. And I think it should be reversed. I think the trial court ought to make the findings, or at least he shouldn't say something that makes it read like he's not considering the findings. I mean, if you don't say anything, that's fine. But don't make a statement like there's nothing to do in sentencing except to impose the 8 years. You shouldn't say that. And you can't use State versus Little to back it up. That's my argument. If there are no other questions, I reserve the rest of my time for rebuttal.
Thank you.
I ask that the court reverse and remand. Thank you.
Thank you. Good morning, Attorney Sauter.
Good morning, Your Honor. May it please the court, counsel. I think the court hit the nail on the head with its analysis and its questioning. The original, if you want to call it a sentencing hearing or a plea hearing, whatever you want to call it, the tenor of the discussion was that Mr. Anderson deserved the 8 years, but the trial court was willing to give him a break because he had been compliant, and he was willing to reduce that to the 3 years that they discussed. When that fell apart and we came back again in September of 2019, the trial court discussed the seriousness factors. The trial court explicitly complied with RC 2911 and 12, stated that there was a large amount of drugs. He was already been on probation to the same judge on a weapons charge. I think that the record is replete with the trial court's consideration. In addition, and
I guess maybe part of Mr. Hoffman's argument is that was discussed at a plea hearing rather than a sentencing hearing. Should that factor into the analysis at the end of the day?
Well, I think that what the trial court did was reflect back to what happened at the original hearing to indicate that he had considered those factors at that time, and I think the record supports that. In addition, at the time of the second hearing, as the panel has already noted, that the recidivism factors that the trial court's permitted to consider under Chandler and Lowry. In this case, it was a particularly egregious set of circumstances surrounding his failure to appear. The trial court had given him roughly 10 continuances to take care of his to clear up matters that he had, including some medical issues. And the defendant was set to appear, or scheduled to appear, ordered to appear on February 29th, 2016. Instead of appearing, he sent a forged doctor's excuse to the trial court, indicating that his medical issues had not been cleared up. 2.5 years pass. Defendant doesn't turn himself in. It isn't brought before the court until he's arrested on more than 6 very serious felony charges. I think under these circumstances, the trial court could certainly find that the recidivism factors, seriousness factors weighed in favor of the 8-year sentence that it imposed. The trial court held a complete sentencing hearing at the second time. He discussed the factors. He heard a lengthy mitigation presentation by the defendant and counsel. Any indication that this was a foregone conclusion, I think, is rebutted by the second hearing. The state would just ask the court to affirm the sentence.
Thank you. Attorney Hoffman?
Well, Your Honor, I reviewed the sentencing hearing, and it's possible, as the court already indicated, it's possible to bring out the discussion of the trial court and and find applicable factors with regard to the facts that the trial court stated. But I really think it's difficult to do it with regard to the, when you talk about purposes and principles of sentencing, you've got punishing the offender or protecting the public. And that second one, protecting the public, I don't know where you'd get something that would plug into that factor. I mean, that's what you're doing.
Well, how about the fact that he was supposed to show up for court and he absconded and fled for, I don't know what, 2 or 3 years? I mean, don't we need to protect the public from someone who's not going to live up to his obligations?
Well, to answer that question, maybe also I hearken back to the earliest question of this panel at the beginning of this argument about a court of appeals reviewing or balancing the recidivism and seriousness factors on appeal. Maybe what the court's doing here by reviewing these facts and thinking, well, these facts apply to factors, so the judge must have considered the factors. Maybe that's, I'll be honest with you, I didn't read the Supreme Court case, but I wonder if that's what they're talking about. How you can't, after the fact, assume that a trial court considered all the factors just by the discussion of the facts that he made. I mean, I'm assuming that you're not going to enjoy the presumption. I'm assuming when I make that statement that those affirmative statements of the trial court take this out of a presumption case. If you don't have that, can you actually just go by the discussion and after the fact think, well, the failure to show up, that applies to this factor, so the judge must have considered the factors. I don't know if logically a court can do that. And so I would argue that the court just, I know that this is a very technicality is what you would say. But I remember when before Foster, this was very important. Findings had to be made. And it was an attempt by the Supreme Court to quantify sentencing, to regulate sentencing. Before that, there wasn't much you could do about sentencing. And so I think it is important. The spirit of it ought to be at least observed in this case because of those statements of the trial court and then the lack of any mention of seriousness or recidivism considerations or purposes of principles of sentencing. And so I'd ask that the court would reverse and remand so that the findings could be made at least. If there are no further questions.
Thank you both
Thank
for
you
your
for
arguments
hearing
this
the
morning.
argument.
It was great seeing both of you.
Thank you, Your Honor. It's nice seeing you.
We'll take the matter under submission and issue a timely decision, and have a wonderful afternoon.
Thank you.
Thanks.
Good morning, Judge.
Good morning. Attorney Lerner, you have your video off.
I do. Let me. No, refresh that. Give me just a moment. I'm computer challenged, Judge.
We all are.
If you go to the bottom left,
I see the mute button, but I don't.
there you go.
Here we.
Perfect.
Can you hear me now, Judge?
Perfectly.
Yes. Okay.
All right. Well, good morning.
Morning.
So we're here now on the case of Cummins and Brown LLC and Phyllis E. Brown versus James Cummins, case number C200166. Attorney Lerner?
Yes, Your Honor.
You're here representing the appellant?
I am representing the appellant. Yes, Your Honor.
Okay. And Attorney Misny, you're here representing the appellee?
That is correct.
Okay. And did I pronounce your name correctly?
Yes, you did. Thanks.
Okay, thank you. Okay, Attorney Lerner, would you like to reserve some time?
I would, Your Honor. A couple of minutes at the end, free.
3 minutes?
Yes, Your Honor.
Okay. Whenever you're ready.
Yeah. And may it please the court, I think I'm managing these technical issues better than I thought I could. I'm Donald Lerner, representing the plaintiff appellant in this matter. This matter concerns an issue about court costs arising out of litigation. I assume that the court is familiar with the briefs and knows generally the case, but in quick summary,
And as you know, we also asked for supplemental briefs on the issue of jurisdiction.
I beg your pardon, Judge.
As you also are aware, we also asked for supplemental briefs on the
Yes.
issue of jurisdiction.
Yes, and those were forthcoming by both sides, Your Honor. I assume that you've received both sides supplemental.
That's correct.
All right. This case arose out of the breakup.
Well, and let's talk about jurisdiction for a moment, because that's a threshold consideration. And
Certainly.
you acknowledged in your brief, in your supplemental brief, that the two ways that the court could exercise jurisdiction would be if it reserved jurisdiction, continuing jurisdiction to enforce a settlement agreement, or the settlement agreement was expressly incorporated into the final judgment. And neither of those are the case here. So how can we even consider the merits of the case?
We would agree that the court did not expressly word jurisdiction, although that's not totally clear, because the court in its final entry overruling our motion talks about having issued some kind of a restraining order for the judgment all the way up until long after the settlement entry and up until the overrule of motion. But failing that, the only issue before this court, and the only issue with respect to which we claim jurisdiction was reserved, is the issue of total court costs, all court costs. And that issue is expressly mentioned in the final entry dismissing the case. The settlement entry says defendant shall bear all court costs.
Attorney Lerner, your position is because one of the terms is incorporated into the dismissal entry, that's sufficient.
Yes, that is our position. It clearly, the dismissal entry clearly recites defendant shall bear all court costs. The issue before you is what are all court costs?
Well, this is what makes even that argument a little bit interesting, because obviously there's a settlement agreement and that's not, part of the dismissal entry. So how do we even know what's incorporated?
The settlement, first of all the documents, the full settlement agreement is contained within the record. It was exhibit to the defendant's memorandum contra motion in the trial court. And the full memorandum, the full settlement agreement is part of the record. But the only thing that's an issue here is what the parties meant by all court costs. This is very parallel to this court's decision in Cummins versus York, where this court unanimously in 1900, in a very similar case, held that notwithstanding that the motion wasn't filed until 6 months after the dismissal upon the settlement, the court felt that it had jurisdiction to resolve the settlement issue. The settlement agreement and the entry, the stipulation dismissing the case, both recite the defendant Cummins shall bear all court costs. The only issue before this court and before the trial court is what constitutes all court costs.
But is it what constitutes court costs under the terms of the order or under the terms of the settlement agreement?
Yes, pardon me for a little cliche, but yes, under both. In terms of the settlement agreement doesn't say court costs, as it did in Cummins versus York, in Collins versus York. It says all court costs. We have to attribute some meaning. The intention of the parties is resolved by the words the parties selected to express them. And that we don't find any ambiguity in this record.
Well, but then the Ohio Supreme Court came out and said that depositions aren't court costs.
But that's totally irrelevant, because it said so in the context of the statute. What it says specifically And what the trial court quoted was that there's no statutory authority. We're not addressing statutory authority. We're addressing an agreement. The first three words of our motion in the trial court is the parties agreed. And it's simply the agreement of the parties as expressed in both the settlement agreement and the stipulation of dismissal, which was an exhibit to the settlement agreement. That the defendant, appellee here, shall bear all court costs.
So is it your position that that term, all court costs, is that an ambiguous term or an unambiguous term?
I'm sorry, is it what term?
Is it ambiguous
No,
or unambiguous?
we believe it is not ambiguous, and we're prepared to explain why. But obviously,
At that point, then we're limited not to look at parole evidence.
that's correct. It's a de novo review. Notwithstanding that, there were affidavits filed in support of the motion by both sides. And so since both sides assumed that the court had jurisdiction, just as it did in Collins. And we feel that, and we're about to explain why, we feel that all court costs is very different from court costs. In the Collins case, the court especially found that the parties did not agree that the defendant, after the settlement just before trial, as here. The trial court, this court found that the parties, and there was no dispute, the parties did not agree that deposition costs would be included. The Collins court, this court, and that nevertheless found it appropriate to tax deposition costs in that case. But here we're relying not on the statute, we're relying on the agreement.
Well, but then that brings back the jurisdictional question that I started with. If you're relying on the agreement and the agreement isn't incorporated into the order and there's no carve out, then you're kind of stuck, aren't you?
Well, I don't think so, Your Honor. I think that portion of the agreement, which is at issue here, is expressly stated in.
But you just said you're relying on the agreement, not on the terms of the order. Because if you're relying on the terms of the order, you're going to be stuck because court cost means what the Supreme Court said it means.
Now, the Supreme Court didn't say that, Judge. The Supreme Court said that the statute doesn't authorize the court to tax deposition costs where the depositions aren't used at trial. We contend that's irrelevant. Here, we're going on an agreement, and that agreement is contained in the stipulation, which is journalized in this record. And the parties believe that the trial court had jurisdiction. The trial court believed the parties had the court had jurisdiction. The court ruled, we feel, incorrectly, but the court entertained that, sat on it for 11 months, waited for the Supreme Court to reverse the 10th Circuit, and then followed the Supreme Court on an issue that was not apparent here, and that is a claim that deposition costs could be taxed under the statute. We don't claim that. We claim that the parties, as in Collins, the parties agreed, and that's the basis for jurisdiction, because that's set forth in the dismissal action. Obviously, Judge, you look perplexed, and I can continue on that subject, but prepared to go on to demonstrate the agreement of parties. If you're not satisfied with the jurisdictional argument, there's no point in going on. But it's clear to me that it makes no sense whatsoever. First of all, Collins is clear authority for jurisdiction. In Collins, exactly the same thing happened. There was a settlement just before trial, and 6 months later, here are only 2 days later, but there 6 months later, the plaintiff, Collins, sought the court to tax deposition costs as court costs. The court clearly indicated there that there was no such agreement and found that there were reasons to do it anyway under other Supreme Court precedent. But we don't claim that there was there was a right to tax deposition under the statute. We claim that neither Collins, this court in Collins, nor us here go that far. We simply came, there is an agreement, and it would be absolutely, we're talking about $4,000. It would be absolutely atrocious.
Well, but, and we are only talking about $4,000, and you guys probably spent twice that in legal fees briefing.
You're absolutely right, Judge. But certainly judicial economy would not authorize us to go then even more for filing another lawsuit. If the trial court had no jurisdiction, then we're free to do that.
Yeah, but we can't assume jurisdiction just because judicial economy.
I think that you have jurisdiction for the reasons indicated, and I think Collins is explicit authority for that. The differences between this case and Collins are two. One, we filed immediately, 2 days after the entry went on. In Collins, they waited 6 months, and the court nevertheless found it still had jurisdiction. The other difference is, in Collins, there was an agreement to pay court costs, not an agreement as here to pay all court costs. And the court found the trial court found in Collins that it had authority to examine and tax and assess for reasons that aren't relevant here, assess the deposition cost as costs, even though the parties have not agreed to it. It seems to me that implicit in that is the fact that the trial court had jurisdiction to consider the issue, even though it wasn't raised for 6 months after the dismissal entry went on. And it's clear to me that the agreement to pay court costs is manifest within the entry dismissing the case with prejudice, with defendant coming to bear all court costs. Now, unlike Collins, as I say, we agreed that the government should pay all court costs, not part of the court costs, not the unpaid court costs, not the final court costs, but all court costs. And yes, there is parole to the effect that the parties had a discussion about that before the settlement agreement, but that's not necessarily the result. The result is simple. We have to give parties meaning to find their intention from the words they use. All means all. It doesn't mean partial. According to Merriam-Webster, all means the whole amount. According to Black's Law Dictionary, the same. All means the entire.
Attorney Lerner, you have 1 minute.
Before
To reserve your 3, you have 1.
Yes, thank you, Judge. I see this court is focused on the jurisdictional issue, and I can understand that being troubling. But it's perfectly clear to me that this court's unanimous decision, Judge Berman's decision in Collins, is precedent in fact. This is just an administrative matter, picking up on loose ends that remain in the case. And this case is clearly on the jurisdictional issue, clearly stronger than Collins' case. Thank you.
Thank you. Attorney Misny?
Thank you, and may it please the court. I'll begin with the jurisdictional issue because the court seemed focused on that. The court does not have jurisdiction because the case was dismissed when the parties filed their stipulation of dismissal. The parties never agreed, and the court never expressed in any way that the court retained jurisdiction to enforce the terms of settlement agreements. But Ms. Brown's appeal is based entirely on this theory that Mr. Cummins breached the settlement agreement and that the parties had some other understanding of what the term court costs meant. So the court doesn't have jurisdiction to determine that issue. And really, Ms. Brown's sole assignment of error is that the court did not consider the contractual theory that she put forth before the trial court. And this court just doesn't have jurisdiction to resolve that issue. But I'll also move on to the merits, or actually before I do, I do want to comment on the Collins case, because the Collins case, in that case, there was no issue of what did the parties mean by the words court costs, or did they have some other understanding other than what the court costs actually were. One party was just asking the court to tax deposition expenses as court costs. And the court ended up doing so under this overriding circumstances exception to the general rule, which there's no basis to assume that the parties could have thought that that exception would apply even in the absence of anyone asking for the court to apply that exception, or in the absence of the court determining that that exception applied. But simply put, Mr. Cummins agreed to pay the court costs in this matter, and he did so. He paid them all. He paid exactly the amount that the court told him were the court costs. The court stamped the party's stipulation of dismissal entry with the words "costs paid," and the case was dismissed. Mr. Cummins never agreed to pay anything.
Ms., I guess the appellant had already paid the deposition costs. Is that right?
That's correct.
And she clearly would have known that. Was there any provision in the settlement agreement that would have required Mr. Cummins to reimburse her for costs that had already been paid?
There was not at all. And there wasn't even really an express provision that in the settlement agreement that states anything aside from just what the dismissal entry is. It just says the party shall file a dismissal entry attached as exhibits, I think it was 4, and the dismissal entry shall state as follows. So there's nothing in the agreement that's aside.
I mean, I always understood paying court costs as paying whatever's left in court costs, not what had already been paid. But I think that's more just a practice rather than necessarily how the term is interpreted.
I would agree with that. And I would say that the deposition expenses were never actually court costs in this matter.
Attorney Lerner's position is that he's distinguishing between the term court costs and all court costs. So how would you address that?
I don't think that that's a meaningful distinction at all, because if something's not a court cost, then it's not included in all court costs. It has to be a court cost. And the deposition expenses were never court costs. They were never taxed as court costs by the court. The court expressly declined to do so. And so regardless of whether it says all court costs or every single court cost or, the entire universe of court costs, whatever it says, deposition expenses were never court costs.
I ask you, Mr. Misny, that Mr. Lerner, I believe in his brief indicated that Ms. Brown believes the court costs were about $5,400. And he alluded to that there may be some parole evidence, which obviously we can't consider at this point. But at the time the settlement agreement was reached, was your client aware that there was a cost statement indicating that court costs were about $5,400, or was that discussed? Was that number discussed?
Yes, we were fully aware of what the court cost statement said. We went on the website, and there was, I think the court's cost statement is submitted into evidence, but there were certain charges on the cost statement that were indicated as invoice only, indicating that the court didn't actually incur those costs. They were just transcripts. They were just invoices that Ms. Brown sent to the court. And so those were included on the cost statements and denoted invoice only. Now the Hamilton County Court of Common Pleas website says for final court costs to contact the cost desk.
Right.
And so
I understand that. My question is, though, was at the time the settlement was reached, was it contemplated by your client that the court costing amounted to $5,400 is my question.
Right, so it wasn't, because we had contacted the cost desk for the final amount before reaching the settlement.
Okay.
Our understanding is what the cost desk told us.
So the $5,400 is just what Ms. Brown believes the total court cost should be.
Apparently, from what she says in her brief, that's her position.
Okay.
We had contacted the cost desk prior to entering the agreement, so our understanding was exactly what the court told us.
Well, I know the clerks are trained not to accept those final entries until such time as all court costs, at least as they determine them to be, are paid. So, all right, well, thank you, answered my question.
And I would also add
Attorney
that
Disney, if these deposition costs are not court costs, what are they?
litigation expenses of one party. I'm not sure how else to characterize them other than that, but they're not costs that the court ever incurred, and they weren't ever used at trial. So decisions in Barry versus Singer back in the 70s, and then more recently in Bossman, that they just are not court costs. I think that's really about all that I have to say. If the court has any additional questions for me, I'd be happy to answer any of those.
Thank you for your argument. Attorney Lerner?
Yes, Your Honor. We call to your attention the fact that this record on appeal contains 3 separate editions of the cost statement issued by the clerk of courts contemporaneous with the settlement. They are TD 76, 77, and 78, each of which shows total costs to be $5,400.95. Those were, as the affidavit showed, discussed with the parties before the settlement. But the fact is that they are a part of the record, and that's what the total costs were, according to the records of the clerk of court, as distinguished from the unpaid balance. To ignore the deposition costs that were indicated to be the total cost at the time the parties entered into the settlement would be to give no meaning to the word all. These parties are bound by the words they
Well, not
selected.
necessarily, because I think it goes to the same questions I asked Attorney Misny of what are they if they're not court costs. So, you know, if they're litigation costs and not court costs, then it doesn't undermine in any way the term all court costs.
Something can be court costs and litigation costs at the same time, Your Honor. The issue is what was the intent of the parties, what intent is ascribed to the parties by the words they selected. They did not, as they did in Collins, say court costs. They said all court costs.
But I mean, isn't Mr. Misny right that if they're not court costs, adding the all modifier doesn't suddenly transform them into court costs?
Well, if they're not court costs, then the clerk of courts was mistaken and included them in total court costs, because 4 times in 3 documents that are part of this record, the clerk of courts indicated total cost to be $5,400 and change. Well, it's not what they might be.
That goes exactly to the issue. Total costs. Total cost is different than all total court costs.
It could be, Your Honor, but nevertheless, all court costs would subsume total cost. It has to be. Other meanings in the word all have. So for these reasons, I urge this court to find the language unambiguous, to review de novo, and find that these costs by agreement of the parties included the obligations of summons that are required to be paid. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. And I wish you both a wonderful afternoon.
Thank you as well, Your Honor. Thank you.
Thank you.